Hello, welcome to Listen and Score. How is everything going on? Hope fine. This channel is meant to read for you. Please subscribe and share so that this reaches many people. This definitely helps the students in revising the concepts, what they already know, and this also improves your scores. And today this particular video is for law of contract, unit 1, part 3, LLB first semester. So we are going to read the doctrine of privity of contract. Also exemptions to the privity of contract. Meaning, privy, a person having a part of interest in any action, matter of thing. Privity, a relation between two parties that is recognized by law. Example, that of a blood, lease or service. Doctrine of privity of contract means a contract is a contract between the parties only and no third person can sue upon it even if it is avowedly made for his benefit. This means a stranger to contract cannot sue. As for English law, it is a well settled rule of English law that consideration must move from the promisee alone. A person who is not a party to the contract but is intended to be the beneficiary under the contract and is nearly related to the promisee has the right of action. This old view was rejected in 1861 from the case of Tweddles versus Atkinson, 1861. Let's do the case study. Stranger to contract, English law. Brief facts. A and B were the bridegrooms and bride. There was a contract between A's father and B's father that each would pay a certain sum of money to A and that A would have the power to sue for such sums. After the death of A's father and B's father, A brought an action against the executors of the B's father to recover the promised amount. Judgment. Court of Appeal held that A had no right to claim as he was the third person to the contract. Since the decision of Tweddles versus Atkinson in 1861, the rule of privity contract, stranger has no right to sue, came into existence in England. The same was affirmed in Dunlop's case. Dunlop Pneumatic Tire Company versus Selfridge and Company Limited, 1915 AC 847. Stranger to contract. Right. Brief facts. Dunlop Pneumatic Tire Company was the plaintiff. It was manufacturing tires. It sold certain quantity of tires to one Dew and Company, who had given a written undertaking and agreement that Dew and Company would sell the tires on listed price only. And if it sold them to any third party, Dew and Company would obtain similar undertaking to maintain the price list. Dew and Company sold the motor tires to the defendant company. The defendant company sold the tires below the list price to its customers. A confusion arose in the market and customers regarding the prices of plaintiff's tires. The plaintiff company brought an action against the defendants. Judgment. The House of Lords held that, assuming the plaintiff company was an undisclosed principal and no consideration was moved from it to the defendant company, and that the contract also unenforceable by them. Principle. One of the fundamental principles of law of contract of England is that only a person who is a party to a contract can sue on it. The principle of stranger to contract cannot bring an action. This is under Indian law. It is equally applicable in India as in England, but our law is more wider than English law. Section 2D of the Indian Contract Act 1872 defines consideration. Section 2D. When at the desire of the promiser, the promisee or any other person has done abstained from doing, does or abstains from doing or promises to do or abstains from doing something, such act or abstinence or promise is called a consideration for the promise. The phrase in section 2D, the promisee or any other person, gives the meaning that as long as there is a consideration for a promise, it is immaterial who has furnished it, if the promiser has no objection. Yet, the common law principle of privity to contract is generally applicable in India. Chinnaya versus Ramaya, 1882, 4 MAD 137. Stranger to contract, Indian law. Brief facts. An old woman had certain landed property. The plaintiff in this case was her sister. The defendant was her daughter. The old woman executed a registered gift deed in favor of her daughter, defendant. In the said gift deed, the old woman put a condition that the defendant should pay a sum of rupees 653 annually to the plaintiff or sister. For this condition, the defendant too agreed. She also executed another agreement in favor of the plaintiff, agreeing to pay annuity to the plaintiff. The property was put into the possession of the defendant or daughter. However, the defendant failed to pay annuity to the plaintiff as per the agreements. The plaintiff brought a suit for annuity. The defendant argued that she did not give consideration and also the plaintiff was a third party. Her contention was that the defendant's promise was given to the plaintiff, but consideration was furnished by the plaintiff's sister. Judgment. The Madras High Court came to the conclusion that both the agreements were valid and the defendant should pay annuity to the plaintiff. Exceptions to the privity of contract. The exceptions to the rule, stranger cannot sue, are found in the contract of agency, bill of lading negotiable instruments, railway receipts, transfer of property, etc. Some of them are summoned upon in the following heads. Number 1, trust of contractual rights. Number 2, conduct, acknowledgement or admission. Number 3, family arrangements or settlements. Number 4, covenants running with the land, etc. Trust of contractual rights. A trust is created by one person maintained by another person for the benefit of third person. Trust is one of the exceptions to the doctrine of privity of contract. Rana Umanath Bhaksh Singh versus Jang Bahadur. Doctrine of privity contract, exception trust. Brief facts. A and B were the sons of C. A was major and B was still minor. C appointed A as his successor and put in possession of his entire estate by a deed. In the same deed, C instructed A to give a village to B on his attaining majority. B, after attaining his majority, asked A to give his property. A refused, saying that B was a stranger to the contract. Judgment. Privy Council held that a trust was created in favor of B, for which the specified amount and village, hence B was entitled to maintain the suit. Problem. C was married to A's son D. C and D were minors at the time of marriage. After marriage, C sued A to recover allowances to be paid by A to C under the agreement between A and C's fathers. Advice. What is the principle laid down in that case? Solution. Yes, C is entitled for the allowance and A is liable to pay. The following liable to pay. Now the second one, conduct acknowledgement or admission. Sometimes there may be no privity of contract between the two parties. But if one of them by his conduct, acknowledgement or admission recognizes the right of the others to sue him, he may be liable on the basis of the law of estoppel. Such acknowledgement may be expressed or implied. Devaraja URS versus Ramakrishnaya. Privity of contract, exception estoppel. Brief facts. A was the house owner. He took some loan from C. A sold his house to B under a registered sale deed. And A took the sale price, deducting the loan amount, and instructed B to pay the loan amount to C directly. B accordingly paid half of the loan amount. He failed to pay the balance amount. C brought an action against B. B contended that C was a third person and he could not sue him. Judgment. Supreme Court held that by the conduct of B, he was stopped to take the plea of stranger cannot sue. Hence, C was entitled to get the balance of the amount from B. Now, the third exception, family arrangements and settlements. Where under a family arrangement, the contract is intended to secure a benefit to a third party, he may sue in his own right as a beneficiary. Family arrangements include such as provision for marriage expenses or maintenance. Veeramma versus Appaya, 1957, AP 965. Privity of contract, exception, family settlements. Property was divided among the family members. Father's share was to be conveyed to his daughter, who undertook to maintain him in his lifetime. It was held that she was entitled to the property, even though she was not a party to the contract. Covenants running with the land. This exception applies to the transfer of immovable property. When the ownership changes from one person to another, the new one has to obey the obligations which were already agreed and running with the land. such as water supply canals, ways, cartways, etc. to the adjacent owners. So this is all in this video. If you have not yet subscribed, please subscribe and share to your friends so that they will also get a benefit out of it. And again, we want to confirm that we are only reading out from the content available with us. You can cross check with your knowledge and the information what you have. This video is only to help you in scoring more with less effort. We are here to read for you. Thank you.